Inside the exquisitely beautiful and ornate U.S. Supreme Court, clothed in marble from Vermont, Alabama, Spain, and Italy, in Washington, D.C., on the morning of January the 10th, 2020, around 9:30 a.m., we'll start with the summoning of the 9 Supreme Court justices to the conference room. This private of private chambers, an inner sanctum of sorts, will be ushered by the junior Justice Brett Kavanaugh. Justice Kavanaugh will act as doorman, gopher, tea-boy, and secretary as the needs of the other 8 justices arise. No other persons are allowed in this chamber. No clerks, no secretaries, no chefs, no police, no public, and definitely no media. Thus the surprising and special role of the junior justice. This role can go on for years, depending on how soon a new justice joins the club. The justices will exchange their ritual handshakes, maintaining their collegiality, but this week the handshakes may feel a little different. This week in particular, there may be an air of business not as usual. Those handshakes, accompanied by eye contact, may convey irregular and uncertain, unspoken messages emanating from the glowing, red-hot case in the pile of cases before them on the conference table. The justices will take their seats on their leather-upholstered executive chairs at the long, fine-crafted conference table. The Chief Justice, John Roberts, sits at the east end of the table. The other justices, in order of seniority, Thomas, Ginsburg, Breyer, Alito, Sotomayor, Kagan, Gorsuch, and finally Kavanaugh, sit where they have chosen. It would appear that Justice Kavanaugh just gets the last unchosen seat. The copy of the day's agenda, the long list of cases petitioning SCOTUS for certiorari, looms in front of them. There, glowing through the pages, that red-hot case, simmering, smoking slightly, and definitely very present, since they all have been reading it over the past month. What is it about case number 19-6548 that would in any way not be business as usual? What about case number 19-6548 could grind the gears of the U.S. Supreme Court to an uncomfortable halt? What is it about case number 19-6548 that will have the justices out at sea, maybe for the first time ever? Just how will Chief Justice John G. Roberts, who introduces each case with preliminary comments, handle the discussion of case number 19-6548 against the Smithsonian Institution, in which he is the Chancellor of the Smithsonian Board of Regents? How will the Chief Justice address the issue that he, in his capacity as Chancellor of the Smithsonian Board of Regents, is a defendant in case number 19-6548, Julian Marcus Raven versus the Smithsonian Institution? Case number 19-6548 at the U.S. Supreme Court is primarily about the entity status of the Smithsonian Institution. Simply, just what is the Smithsonian Institution? But this unanswered question of federal law is like a standing domino just itching to be toppled, setting off a cascade of a whole litany of unresolved legal issues once SCOTUS begins to answer this question. Or will they just ignore the unanswered federal question because of the insignificant, self-represented, and oft-disdained status of the pro se petitioner? Some of the cascading, ensuing, unanswered questions are: is the Smithsonian a private institution or an arm of the federal government? Who can enforce the public trust when corruption contaminates the once venerable institution? Does the Uniform Trust Code for the District of Columbia apply? Does the First Amendment Free Speech Clause, the Fifth Amendment Due Process Clause, and the Fifth Amendment Equal Protection Clause of the U.S. Constitution apply to the federal government when acting as trustee? These questions for now have been shut out by the absurd ruling of the district court, effectively stating that the Smithsonian Institution is a full-blooded federal agency and that we the people are owed no fiduciary duties by the Smithsonian trustees and that we the people have no free speech rights or any other constitutional rights when participating in our very own Smithsonian. You see, mysteriously, the District Court and the Court of Appeals for the District of Columbia Circuit have denied the principal congressionally established status of the Smithsonian Institution as simply a public trust that is merely run by the federal government as trustee. Denying the trust status excused the Board of Regents, including Chancellor John G. Roberts and the other Smithsonian officials, of illegally throwing both my Smithsonian Trust participatory application and subsequent appeal out into the streets without any lawful due process, effectively yelling, "You have no rights here. Get out, you deplorable Trump-supporting wretch." In the upcoming Friday, January the 10th, 2020 SCOTUS conference, the 9 justices will face the dilemma and implications of answering the unanswered question of federal law. Granting cert will ultimately, when I prevail, send my case back to the district court, where my breach of trust claims can be lawfully brought against Chancellor John G. Roberts, who is sitting at the SCOTUS conference table, the other 16 regents, and Smithsonian National Portrait Gallery Director Kim Sayet and Dr. Richard Curran, etc., for breaches of fiduciary trust. The other half of case number 19-6548, that is before SCOTUS, is composed of my constitutional claims. It will only take 4 out of 9 votes to grant the petition. Could this vote, and which justices dare cast the ballot, unmask any superficial collegiality and hidden animosity within the bench as a way of payback for a perceived constitutional betrayal of one of the Chief Justice's former votes or opinions? Could this vote expose some hidden jealousy that 8 of the 9 justices are not the Chief Justice and may never be such? Or maybe the Chief Justice wields a power that is best to avoid, and so just all bow out and just jettison that silly and frivolous case. After all, it is just that nobody, self-represented commoner and Trump-supporting deplorable former foreigner artist Julian Raven. After all, the justices are only fallen human beings. The intrigue, although speculative, may be revelatory as to the real politics, personal agendas, and human undercurrents of SCOTUS. You can see now why, oh why, it would be remarkable to be a fly on that wall, to see how the gears come to a grinding halt, to hear that awkward silence settle in when case number 19-6548 snags and jams the system. This is the second time I have appealed to John G. Roberts. Will Chief Justice John Roberts finally hear my appeal, recuse himself, and humbly recognize that it is time to answer the unanswered question that will be on the SCOTUS conference agenda this coming Friday, the 10th of January, 2020, in Washington, D.C.?